We've got some shocking news. The ATF is now ignoring a permanent nationwide block on the pistol brace rule. This threatens the rights of millions of law-abiding gun owners across the country. In this video, we'll talk about how the ATF is effectively defying multiple court orders and what that means for you, your firearms, and the future of Second Amendment rights in America. Before we dive into the exact details of this unfolding situation, let's set the stage. The ATF's pistol brace rule has been a controversial and highly contested regulation that effectively reclassifies pistols equipped with stabilizing braces as short-barreled rifles under the NFA. This reclassification is not a minor issue. Under the NFA, SBRs are subject to stringent controls, including registration, taxation, and potential legal penalties if owners fail to comply. Historically, the ATF claimed that only specific setups would count as an SBR, using a so-called factoring test that looked at surface area, length, weight, marketing materials, and how the brace was intended to be used or shouldered. The trouble is that factoring test was vague, subjective, and impossible for the average owner to interpret reliably. Multiple lawsuits arose in response, with our allies, organizations such as Gun Owners of America, and other pro-Second Amendment groups challenging the legality and constitutionality of the ATF's brace rule. Courts began to push back. An important moment came when a federal judge in the Northern District of Texas issued a ruling vacating the pistol brace rule nationwide. That meant, in straightforward language, that the ATF's rule was struck down and not enforceable anywhere in the country. Beyond that, there were preliminary injunctions protecting specific organizations and their members, including one involving Gun Owners of America, who secured an injunction so that their members would not be subjected to the rule's enforcement. Now, most people assume this matter was largely settled pending appeals. If it was vacated across the country, that should mean the entire rule is on hold, right? Well, apparently not in the eyes of the ATF. And we all know how it is with a rogue agency that has historically been above the law. Despite the courts, despite the ongoing appeals, despite multiple judges explicitly stating that the pistol brace rule is vacated, the ATF has still found a way to interpret and enforce their viewpoint that all brace-equipped pistols remain SBRs under the statutory language of the NFA. Essentially, they're saying, we don't need the rule to say they're SBRs. The statute itself says so. And this is where it gets extremely frustrating, because it suggests the ATF isn't just ignoring the courts, but that they may be broadening their interpretation even more aggressively than before. Let's lay out the recent developments in detail, because it's one thing to say the ATF is defying a court order, and it's another to understand exactly what that means for gun owners. In December 2024, a Gun Owners of America member reached out to the ATF for clarity on whether they could attach a brace to a newly purchased pistol. A CZ Scorpion Mini in this instance? This member wasn't sure how to proceed, given the conflicting information floating around online, the court rulings, and the claims of a nationwide block on the brace rule. They emailed the ATF's Firearms Industry Programs Branch, or FIPB, which is typically tasked with clarifying federal firearm regulations for manufacturers, dealers, and occasionally curious members of the public. The ATF's response was nothing short of startling. They indicated that if a pistol has a stabilizing brace attached, then, as a matter of law, it's considered a short-barreled rifle. No factoring test, no context, no nuance. The mere presence of a brace on a pistol apparently transforms it into an SBR in their eyes. Moreover, the email went on to acknowledge that even though the rule had been vacated, the ATF still feels it's responsible for enforcement of statutory provisions under the NFA. In simpler terms, they're saying, yes, our rule might be blocked by the courts, but we believe we can enforce the same restrictions under the wording of the National Firearms Act itself. This response flew in the face of everything the courts have recently stated. There is a permanent, or at least indefinite, nationwide block, multiple injunctions, and an ongoing appeal at the Fifth Circuit. Each of these legal developments would lead a reasonable person to believe that the ATF could not enforce any version of the pistol brace rule. Yet here we are. And it's not as though the ATF gave a nuanced, limited statement either. This email, according to Gun Owners of America's summary, took the broad view that any brace on any pistol automatically triggers classification as an SBR, which is arguably even more expansive than the factoring test in the original rule. We're only in the early part of this fight, and it's already having massive repercussions. I personally think this brazen defiance of court orders is a clear example of government overreach, but you can comment below what you think. Anyway, the immediate concern is what this means for everyday gun owners. If the ATF is claiming that every pistol with a brace is automatically an SBR, that opens the door to serious legal consequences for people who haven't paid attention to the rule or who've believed themselves covered by the recent court decisions. We're talking about potential felony charges for owning what many had assumed was a legal setup. For years, the ATF had letters and guidance essentially permitting braces on pistols as long as you didn't use them to create an intended SBR. But now, with no advanced notice, they're taking a position that could potentially criminalize a huge population of gun owners who haven't registered anything under the NFA because they never thought they had to. GOA, in response to this baffling about-face by the ATF, escalated the matter. They initially requested that the FIPB clarify whether they're really adopting this stance across the board. GOA gave them until January 8th to respond, but the ATF apparently did not meet that request with any clarification. As a result, GOA had to bring the matter to higher levels within the Bureau. If you read Eric Pratt's letter to the ATF, it's very clear that GOA is alarmed by what they interpret as an attempt to circumvent the courts. The letter highlights that the ATF's new approach is effectively the same as, or even more encompassing than, the vacated rule, which might constitute a direct violation of various federal court orders. Now think about the ramifications if the ATF gets away with this approach. It sets a precedent where an agency can be blocked by the courts from enforcing a regulation, then pivot to say, we don't need that regulation. We can do the exact same thing under a more general interpretation. That's a slippery slope, because if the ATF can do it here, nothing stops other agencies from pulling a similar strategy when courts strike down their rules. It's not just a Second Amendment problem. This is a question of constitutional checks and balances, and whether a federal agency must adhere to a court order or can simply find a back door by reinterpreting existing statutes to enforce the same restrictions. GOA isn't the only group watching this closely. Other gun rights organizations and various attorneys general across different states are monitoring how the ATF is conducting itself. The judge who issued the nationwide vacatur in the Northern District of Texas is certainly going to take notice if the ATF keeps publicly contradicting or ignoring the effect of his order. And the Fifth Circuit, which acknowledged that the rule is indeed vacated nationwide, might not take kindly to an agency ignoring their authority. That sets up a potential showdown that could escalate quickly, especially if the ATF tries to prosecute someone, or if local law enforcement tries to pursue charges based on the ATF's stance. It's also worth mentioning the political element of this saga. At some point, the presidential administration could change, which often brings a new ATF director and shifting priorities. If there's a new administration that's more friendly toward gun rights, the entire approach to the pistol brace issue could flip yet again. But even that wouldn't undo the fundamental problem we're seeing here, that the ATF seems willing to step around the courts to enforce a viewpoint that is not held up in multiple legal battles. It's like a game of whack-a-mole. Every time a judge strikes down the rule, the ATF pops up somewhere else, claiming a new interpretation. Organizations like GOA and their legal teams are prepared to bring this to the courts if necessary. They've indicated that the ATF's admission, documented in that email to a GOA member, is evidence that the agency is violating court orders. This could become a vital piece of evidence in ongoing litigation, showing that the ATF is willfully ignoring the judiciary. Still, these lawsuits take time, and in the meantime, gun owners are left in limbo, wondering if they'll face sudden enforcement action for an accessory they've owned legally for years. That's what makes this so urgent. It's not just theoretical. It can lead to real-life consequences, especially in places where local law enforcement cooperates heavily with federal agencies. One day you think you're in full compliance with the law, protected by a nationwide injunction, and the next day you find out the ATF has decided that injunction doesn't really matter. So, while we wait for a final resolution, we should get as much public attention and discussion on this as possible. Nothing changes if people remain unaware that the ATF is moving forward in spite of the courts. On that note, if you feel strongly about protecting the Second Amendment, consider supporting groups like Gun Owners of America, who are on the front lines of these legal battles. They're actively fighting back, requesting further clarification, and gathering evidence for new motions in court. The more members and support they have, the stronger their case becomes. The same goes for staying engaged with your local representatives and staying on top of legislative developments. Even if you're not directly affected by the brace rule right now, these precedents could shape how firearm regulations are enforced for years to come. What we could see soon is either more clarification from the ATF or the complete lack thereof, and another round of legal showdowns. GOA had asked for a written response by January 14th. If the ATF maintains its posture, we can expect that to be highlighted in every relevant courtroom, whether it's in Texas or before the Fifth Circuit or any other jurisdiction that's weighing in on the brace rule. That means any new lawsuits or appeals are likely to cite the ATF's stance as evidence of overreach or possibly even contempt of court orders. And if the courts agree, it might result in even harsher rebukes or stricter injunctions against the agency. On the other hand, if the ATF decides to back off because of the public scrutiny or because their lawyers advise them that this is going to end badly, it might reduce the immediate threat to brace owners, but only time will tell if such a retreat is in the cards. Where does this leave law-abiding gun owners at the moment? The safest course of action is to stay well informed about any new developments, especially if you're someone who owns a pistol brace. Even though the courts have vacated the rule, we now have evidence that the ATF might treat any brace-equipped pistol as an NFA item. That presents a risk, though it also provides a basis for a legal defense. God forbid an owner were prosecuted. Until we have absolute clarity, many gun owners feel stuck in a legal gray area. If you decide you want to remove your brace, register your firearm, or keep it as is while relying on the court orders, that's ultimately your decision. But be sure you understand the potential pros and cons in the current climate, and consider talking to a lawyer who specializes in firearms law if you need specific legal advice. Don't rely on hearsay or random online opinions when your freedom could be at stake. As for me, I find it unsettling that a federal agency would flaunt nationwide court rulings. The entire concept of judicial review is meant to be a safeguard. When an agency oversteps or creates rules beyond their authority, the courts are supposed to step in and correct it. That's the system we have. But if the agency disregards those corrections, it fundamentally undermines our entire legal structure. This isn't just about pistol braces anymore. It's about the very fabric of our government, the separation of powers, the checks and balances in place to protect our constitutional rights, and the grand plan that no single agency can act as judge, jury, and executioner. It's now under threat. But that's all we have for you in this video. If it was helpful in any way, please like, share it with your friends to spread awareness, subscribe to our channel if you haven't already, and click on the bell icon for more of these videos. We appreciate all your support. Thanks for watching, and God bless America.